Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready. 5 seconds. Start. The power of the High Court under Section 482 of the Code in a situation as this, when called upon to quash a complaint at the very threshold, are considerably limited, while the conditions on which and the circumstances in which the High Court may interfere in criminal proceedings at the threshold have advisedly been not legislative or judicially illustrated or defined with a mathematical precision. It is not difficult to spell out from decided cases broad guidelines in dealing with a challenge to such proceedings at the initial stage, even though it is well settled that these principles are not of universal application, and as always, each case has to be decided on its own merits. It is therefore well settled that ordinarily criminal proceedings must be tried under the Criminal Procedure Code, and the High Court should be reluctant to interfere at an interlocutory stage. But there are situations where inherent jurisdiction to quash proceedings can and should be exercised, such as one where it manifestly appears that there is a legal bar against the institution or continuance of the criminal proceedings in respect of the offence alleged, or two, where the allegations in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not constitute the offence alleged, or three, where the allegations do constitute an offence but there is either no legal evidence adduced in support of the case, or the evidence adduced clearly, fairly, or manifestly fails to prove the charge. In dealing with this class of cases, it is important to bear in mind the distinction between a case where there is no legal evidence or where there is evidence which is manifestly and clearly inconsistent with accusation made, and where there is legal evidence which, on appreciation, may or may not support the accusation in question. In exercising its jurisdiction, the High Court would not embark upon an inquiry as to whether the evidence in question is reliable or not, because that is the function of trial court, and it would not be open to a party to invoke the inherent jurisdiction of the court and contend that on a reasonable appreciation of the evidence the accusation made against the accused would not be sustained. The above tests, if slightly widened, it may be safely held that in the following cases, an order of the magistrate issuing process against the accused can be quashed or set aside. That's all.